Hi everyone, my name is Asaf and I'm a plaintiff's employment attorney here in Los Angeles, California. This is the first of a video blog series that I'm going to be starting to explain certain laws with respect to how they affect employees in the wake of the whole COVID-19 pandemic. And hopefully it's helpful and it's something that employees in California can use as a resource to learn about how these things may affect them and hopefully try to clarify some of these issues that surround these particular laws that are coming out, and they are changing quite rapidly. So even what I might be saying today may change or may have additions to it in a week, but hopefully it's helpful. Today's topic is actually going to be around the Family First Coronavirus Response Act, and specifically with respect to the emergency paid leave. So this is relatively new. The effective date is April 1st, 2020, so it just went into effect less than 2 weeks ago, and it's set to expire on December 31st, 2020. That may change depending on how things go. What it is essentially it's a law that's supposed to provide emergency paid leave to workers who are in some way, shape, or form affected by COVID-19, and I'll kind of get into that later. And there's also going to be just a small outline about what are the things that I'm talking about, so that everyone can understand what's going on. So the second question is who's covered. Under this particular act, only private sector employees that employ 500 employees or less are covered by the act. So if you're an employee for a corporation, for example, or a company that employs more than 500 people, this would not apply to you. Moreover, there are certain exemptions, even if the company is one that only has less than 500 employees and is a private employer, but we'll get into that later. And then also, if you're a public sector employee, there is no particular cap or minimum for the amount of employees. This will cover you regardless of the number of employees that work for the particular public agency. And so what is it and how do you qualify for it? There's 6 particular categories, and 1 through 3 have a different pay rate if you go out on emergency leave than do 4 through 6. I'll quickly run through them. They will be referenced in the outline, or that is going to be included as well. So number 1 is if the employee is unable to work or telework because the employee themselves is subject to like a federal, state, or local quarantine that's related to COVID-19. Number 2 is if the employee has been advised by a healthcare provider to self-quarantine due to COVID-19. Number 3 is if the employee is unable to work because they're experiencing COVID-19 symptoms and are seeking a medical diagnosis. Then they can be entitled to leave. In addition, number 4 through 6, which do not relate to the employee themselves, are also things that would allow an employee to qualify for the emergency paid leave. Number 4 is if the employee is unable to work because they're caring for an individual who's subject to a federal, state, or local quarantine, isolation order, and has been advised by a healthcare provider to self-quarantine. Number 5, if the employee is caring for his or her child whose school or place of care is closed as a result of some kind of a reason that's related to COVID-19. And number 6 is if the employee is unable to work or telework because they're experiencing any other substantially similar conditions specified by the U.S. Department of Health and Human Services, which kind of just is a catch-all and leaves it kind of open. I guess the main question is, well, how much is an employee entitled to? Um, well, it depends. The first thing is to know that both part-time and full-time employees qualify for this thing. So you don't necessarily have to be a full-time employee to be able to take emergency paid leave. If you're a full-time employee, you can get up to 2 weeks or 80 hours of pay. If you're a part-time employee, you'll get the number of hours equal to the number of hours that you work on average over a 2-week period. So that's how that's going to work. It's going to be an averaging of the hours that you work. The required rate of pay is going to be the highest applicable wage rate of either the employee's regular rate of pay or the federal minimum or the highest applicable state or municipal minimum wage. So for California, it's gonna definitely be your regular rate of pay, which should be at least the minimum for your municipality. The payment amount is going to differ depending on which one of the 6 reasons you're qualifying for under the Act. So reasons 1 to 3, you're going to be able, the employee will be able to get 100% of their wages for that 2-week period. Again, that is if their employee themselves is subject to a state, federal, or local quarantine or isolation order related to COVID-19, or if they've been advised by a healthcare provider that they need to self-isolate or self-quarantine because of COVID-19, or if they are experiencing COVID-19 symptoms and are required to self-quarantine. For these particular amounts, the employee is entitled to 100% of their pay, but it's capped at $511 per day or $5,110 in the aggregate, so for 10 total days. So even if you do earn more than that, you may not necessarily be able to get it because it is capped. For reasons 4 through 6, the employee is going to be able to get 2/3 of their rate of pay for the hours taken. And that's for 4 through 6. Those are the reasons, or if you're caring for somebody who has to quarantine or is sick because of COVID-19, or if your child, for example, is their place of care or school is closed because of COVID-19, then that kind of compensation is what they would receive. They would receive 2/3 of up to 2/3 of their regular payment that they would normally receive. This, however, is also capped, but to even less. It's capped at $200 per day or $2,000 in the aggregate. So it's something to keep in mind. There are certain safeguards that are built into this act to protect employees, namely that your employer cannot require you to use your accrued paid time off or sick time before exercising the ability to use the emergency paid leave. So that there is no requirements that something needs to be exhausted before this. If they do that, it's unlawful. Moreover, there are certain exemptions, as I alluded to earlier, to private sector employees, even if they are they work for a company that employs 500 or less employees. There are 2 exemptions, namely the first is a small business exemption, and that's for employers that have fewer than 50 people, and that's a very limited exemption, and it only comes into play if the leave is because of a child's school or place of care is closed, or a child care provider is unavailable due to COVID-19 related problems, and the employer has to certify that the requirements of the FFCRA would jeopardize business viability. I'm not going to really get into that about what the requirements are because that's more of a topic for employers, and this is a video blog that's geared towards educating employees. But it's something to keep in mind that if you do work for an employer with less than 50 people, and one of the reason you're going out for, namely reason number 4, is because you, due to childcare because of COVID-19, they may apply for an exemption, and you may be exempt from emergency paid leave. The second exemption, which is probably going to be the most common and unfortunately the most difficult for a lot of people, is if you are a healthcare provider or an emergency responder. And that's a pretty broad range of folks, doctors, nurses, police officers, EMTs, and more. And there's a list of what's considered a first responder or a healthcare provider on the Department of Labor website that's related to this, and I can also post a link. Finally, one other issue to keep in mind are employee layoff issues. Specifically, this is only really going to come into play for folks that were or employees that were laid off prior to this being enacted, or layoff in the process of while this is enacted. So for example, if you're an employee, if there was an employee that was laid off prior to April 1st, 2020, then this does not apply because this came into effect on April 1st, 2020. If, for example, a business closes after April 1st, but before the employee takes the leave, then the requirements don't apply except to the days from April 1st to the date of the layoff. So in this case, if the employee took leave on March 28th and the doctor's note said that they were off until April 12th, for example, and the business closed on April 7th, then the employee is only technically entitled to the days that they would have worked between April 1st and April 7th, not necessarily after, because it cuts off at that point. And finally, with respect to employee layoff issues, if a business is open, but if they lay off part of its workforce, then the employees who are laid off or furloughed are not entitled to any leave under the FFCRA. So even if the business is open and you'd been working and the employee had been working there, but then they were furloughed in the middle of their leave, then they technically under this act wouldn't be entitled to the days after they were furloughed or laid off. I hope that this was helpful. Things are really changing. It's a completely different landscape right now with respect to how employers or employees are trying to figure out how to navigate this difficult time. I will be doing more video blogs and putting up more content on trying to explain these various laws as they affect employees as they come up. And if you have any suggestions about different topics that you'd like me to explore, that'd be great. Please just email me or let me know. And if you have any questions about this, if I can answer it, please feel free to reach out. Thank you.